Okay. So as we all know, the syllabus has been recently changed. So it's most of the content is same. It's just rearranged and very little minute changes have been done to content, but most of it is rearranging as we might have already seen in the notes and in comparison with the old material. तो पहले चैप्टर में जो था दैट हैज बीन गॉन टू आई मीन दूसरा चैप्टर का पहले चैप्टर में उन्होंने इंट्रोडक्शन में डाल दिया सो वेरी माइन्यूट चेंजेस विद रिस्पेक्ट टू कंटेंट but with respect to material they have actually changed. They said that now you have to completely rely on this material and online resources that link जो भी उन्होंने भेजा है. So even the link also we have to open and see and read. It may sound like a little bit of foundations. Foundations also, gives you a lot of reading material, but do not worry. Taught, I went through the subject. Taught is not seeming to be a difficult topic to understand, but of course, when I saw the sample paper, it is looking little different. But once we are understanding the concepts, then we can step on to solve the question and answers and practice really well, because this is not like other NCA subjects. All additional subjects are like that only. They are a bit different from the core subjects, and the expectation that they have out of us is also different from thought to other property law or any other subjects. So we will keep that in mind. And now, currently, our focus should be digesting what is there in each section of the syllabus. So today, as this is an introductory first class, we will also, see section A part of the syllabus. We will try to cover those all the 3 chapters, but we will see how much we can cover. But before that, let us have an overview of what and all are there in each section and how the syllabus is divided and what was their idea behind, giving each section. So part A is an introduction to torts. So all the introductory concepts they have put in here, and from this part, as per my research and people who have written the exam also, this from this part the questions may be essay type of questions. The fact pattern questions may not come, but don't make the mistake of skipping the topic as well, because all the time the syllabus part 1, chapter 1, or here we can say section A, is important to know the background or the foundation of that particular concept. So we will not ignore it, we will understand it. The nature, history, function, theoretical approaches, these are important. See, what I learned from my additional subject is that whatever concepts or like terminologies we learn in the first chapter will be given in the question. So in order to get the context of the question, we need to know what are these. Okay. There may not be direct questions from chapter 1 or section 1, but there will be definitely, the terminologies will be put up in such a manner, and we need to know these background knowledge to understand the question on the exam day. So here they have given the page numbers of the the material, prescribed material. Accordingly, I have also prepared the material from the main, but you can see the material is very similar because everybody is now prescribing only one prescribed book is there, right? So we are sticking to that, and anything additional in our question and answers, we will frame our answers quite differently, like a little bit differently, so that you don't get any plagiarism tag, right? But for what you should have on the exam day and what you should learn, you should read all these pages. Okay, all these pages. So it will be there. It is there in our material. Now,
Vidya,
as and when we go, yeah.
so do I need to buy that book, which was
No, you
no,
don't
right?
have to buy, because our notes is prepared by the same book only,
Okay.
based on the same book. So, for example, for first part, they are saying page number 1 to 18. So it is containing page number 1 to 18. Okay.
Yeah.
Then for this one, 20 to 25. So basically, they have like rearranged. You can see, यहाँ से फिर से 18 से शुरू हो रहा है. So उनका बुक ही पढ़ना है, but हमें notes material जब what we should keep, no, like what we should read, that is in different arrangement. So accordingly we will read and we will understand. But कहीं पे concepts are bit exhaustive, we can say. उसको मैंने concise करके देने का कोशिश किया है. So that we will do. And with
Okay.
respect to first part, now this is being very theoretical. So as it is only I have kept. And बाकी का जो भी chapters है, we will come to that as well. And one more material that I'm preparing on the side is the condensed notes that I give you all the time for other subjects. I hear that is helpful. So for revision or like for quick learning or quick understanding of like finding the concept, maybe that will be helpful. So that also I will be giving you, but it may take few days. So currently I will share like section by section, jo actual detailed notes hai, that I will share. Then the second one will be condensed material. And the third material that I am preparing is question answers. Okay. So once we are done with the syllabus, we will discuss each and every question that we get on tort law. I have also collected some and I got from you guys as well. So the questions are there. We had to read them, apply what we are having. So even in the syllabus, you can see there are two links where they're saying tips for writing NCA torts exam, how to answer the fact-based law exam questions. So as per my understanding and experience, whatever they say in the syllabus material, it's not just the syllabus part. Even all of this, learning objectives से लेकर everything is important. So while writing the answers, I will cover all these parts and we will apply whatever they are saying. Each and every instruction of theirs we should cover so that your answer is up to the standards. Okay, and yeah, that is the general things I wanted to say. Then you can see section A to F, I think, yeah. A, B, C, D, E, and F. Total 6 parts, right? 6 parts में divided हुए हैं syllabus, and in 6 parts, how they have divided the concept. So पहला chapter तो it becomes the introduction, and in the introduction again we see 3 chapters. So per section of the syllabus, we have here 3 chapters in this syllabus, and in the 3 chapters, we have first chapter divided into sub chapters. Okay. So if you go as per the syllabus, then we will not leave any concepts. So we should not go as per the concept. We should go as per the syllabus only, and one by one chapter we will cover so that we are covering basically everything in the syllabus. We should not leave anything, especially when the syllabus is changed. We should never ignore that part. And wherever the link is there, I'd like you to read that as well. Open that and read that as well as a secondary kind of understanding for just understanding of that concept. Okay, but totally we will see part by part. Now, first part, as we know, introduction to torts. उसमें concept of tort है, where we learn the nature and history of torts, functions of tort law, theoretical approaches. There are different theoretical approaches that also we understand here. Then basis and scope of liability. So as we know, tort is basically, okay, just give me your understanding of tort, like just an introduction के लिए, your understanding of tort. What is tort?
Like it's not a criminal wrong, like it's a like civil wrong. That's what I remember from my university.
Yeah. So it's a civil wrong, right? It's basically a wrong thing. It's not a crime. We can't say it's a crime, but it's a wrongdoing. It's a wrongdoing. That's absolutely correct. And the interpretation of the concept, like you might remember the concept of recips or loquitur, right? Recips or loquitur is the italic, the Latin Latin verb. तो वहाँ पे what is the meaning of recips or loquitur? How the thing is showing ना, अभी एक fragile material basically, like there is a shipping going on and उसमें एक fragile material है तो वो लोग उस पे sticker डाल देते हैं. They'll put a sticker, this is fragile, don't break, like vulnerable to be broken, right? And आप उसको mishandle करो, right? So that is not a crime, but वो thing item जो है उसको देख के उसमें लिखा भी हुआ है and उसको आप फिर भी like you are ignoring the written thing, the what do you say warning, and you are still not handling it with care, and वो टूट गया. So that time also it is taught, and we'll also see some familiarities there. अभी एक contract होता है, like me and you will get into a contract and there will be obligations on each side and there will be rights of each party also. Rights and obligations will be there. So in a contract, when breach happens, is that taught? Or is it a contract, breach of contract?
It is a
Sometimes-
breach of contract, right? Like torts come under. Okay.
So it could be both. So basically plaintiff को choice दिया गया है. Plaintiff has the choice to choose whether to go as per, to go with the tortious liability or a breach of contract. Okay, so those things we will see in detail. So introduction topic pe, that to first chapter, the concept of tort, we are going to learn about the difference between the crime and tort, the difference between a tortious liability and a breach of contract, and sometimes the facts will be same, but it is going to be the action is going to be different. So we will learn a lot of terms as well, like liability kya hoti hai, absolute liability, strict liability. So these are the concepts that you have already learned in your university, but we have to recap and understand from the point of view of Canadian law. Okay, so we will go into chapter 1 today so that we are not wasting any time and using every bit of minute that we have. Okay, just एक बात देख लो कि ये syllabus कैसे divide हुआ है. Second chapter what we see is intentional torts. Intention and related concepts, remedies in intentional torts. Intentional tort, as the word says, with the intent they have done that particular wrong. See, wrong may happen accidentally, wrong may happen with intention, right? Without intention, accidentally also it may happen, or with intention. So basically we understand the differences and what sort of remedies are there, what are damages, and how it is basically given. Then we have trespass to the person. What do you mean by trespass to the person? Just आपका general understanding आप बोल दो.
किसी के body को like I mean
Trespass करना. Yeah. So
like
trespass is basically passing the boundaries that is already built. Now you can say trespass to property. There is a property with fenced property, and you're jumping through the fence, yeah, breaking the fence or just opening it and coming. So you're not allowed there. So it is called as trespass. Trespass. So trespass to the person also is covered here. And when you see here battery, assault, these are criminal crimes basically, right? These are covered under the criminal code. And how it can be a tortious liability, that also we will be learning. So trespass to the person may, we have battery, assault, wrongful false imprisonment, wrongful prosecution, that is also malicious prosecution, intentional infliction of psychiatric harm, the innominate intentional tort, invasion of privacy, breach of confidence. This is very interesting. आपको ना, I would suggest whenever the concept is like this, like kind of like a number of concepts or topics are more, we should take it bit interestingly and talk subject that we can imagine, because this is day-to-day happening things, right? Like here and there it happens. So just imagine these things and think like bit of like criminal law mein how I used to say, like imagine the facts and imagine the concept, then we will have a better understanding and we will remember the concept. Okay, because even though it is an open book exam, we have to recall the concepts and make a distinction between the topics. समझ लेते हैं, like we will understand the meaning of each of those, and then we will also see the difference. How we used to do difference between the different parts of defenses in criminal law, right? The offenses, of course, they are different, but defenses we used to feel like they are very, very similar, but they are not, right? Sometimes it is for so and so elements are met, then we will give this defense. So similarly, whenever multiple topics are coming, we need to first understand the meaning of it. Then we have to find the difference. Key difference जो हमारे understanding के लिए, not from the exam point of view, I'm saying, just for understanding. Then first one was trespass to person. Second is trespass to property. So trespass to property may we have intentional interference with personal property, that is chattels. Chattels, what do you mean by chattels or personal property? Any idea? Okay. So on the other side is real property. That means real property, real estate, or you can say something that is, kind of a immovable property, land, right? So here we have chattels are basically considered as the personal effects, like my phone, my car, my table, my laptop. So those are basically like movable, and how you are getting interference with your personal property is covered under this part. And intentional interference with real property, trespass to land under statute, trespass under statute, like if it is already covered under any law, that comes under there. And trespass and nuisance. What is the difference between trespass and nuisance? And when it stops being trespass and it becomes nuisance, or how nuisance turns into trespass? So those things also be considered. Trespass to airspace, airspace and subsoil. So subsoil क्या होता है? And how basically trespass to subsoil happens. It's not needed that somebody has to climb the fence and come to your property and touch your soil. No, they can also get that underground thing, mining they are doing, and your properties mining thing also, like they get they mine from your property under your land also. So that subsoil का भी trespass होता है, air space का भी trespass होता है. Like there is two vertical building and one building is like antella, another building का ऊपर they are constructing and they are trespassing the air space, right? That is also there. So basically this is all related to real property. Then third point, यहाँ पे first was trespass to person, trespass to property. Then we have differences in intentional torts. So intentional torts we learn. Now we are learning defenses for those. Consent. If somebody gives you consent, that is also one of the defense that you're seeing. He consented, right? So how that works? Implied consent, exceeding consent, competency to consent. Everything about consent we are going to learn in the context of tort law. And provisional healthcare schemes, all those things we will learn. Then self-defense. So first one was consent. Like it was like they they gave the consent for you to do it. And second is self-defense. You did it out of defense of person. Then defense of third parties, defense of real property, defense and recaption of chattels. Necessity. It was necessity. Then legal authority. Under legal authority, also somebody does something that may be otherwise called as tortious act, but it could be when you have the legal authority to do that, then no, it won't be. It will be a very good defense. Then appointment of fault in intentional torts. Appointment of fault or liability, like for example, apportionment. Apportionment is also where apportionment means portioning, like I have done this part, yes, but the remaining like 90% of the part was done by the victim itself. So apportionment of the fault also, liability also will be divided. So that also we have seen. So there are 8 differences. So हमें सारे पढ़ना है, and of course when we get a fact pattern question, how it will be, they will give you a concept, background story देंगे, and they will say that so and so thing has happened. First of all, you have to identify what is that tortious liability that happened, and you have to categorize it also, whether it is defense to person, the trespass to person, trespass to property, or any other point that we are learning. And under that also any subsection that we have, subcategories we have. So we have to identify, tell the characteristics of those tort, and then we have to say why it is not, that's where your introductory concept also comes. एक दो लाइन वहां पे लिखना ये भी अच्छी बात है कि why it is taught only, it is not a contract thing. They might have given some contract or other points as well, and the client might be asking you like, now what should I do? Should I go as per the contract thing or tort thing, right? So what action should that person get or file? That would be the question. And on the other side, or like sub question or like second question could be of defense as well. What defense that the other person, like who have committed this wrong, can claim? So that also could be asked. Then, so from that point of view, part B is basically having intentional thoughts, and intentional thoughts ka defense also is there. Then part C is consisting of the concept of nuisance. Nuisance, private nuisance, public nuisance. And this is somewhere we saw nuisance, right? So here there is a concept of nuisance and trespass. So here very slightly you are learning about nuisance, but in detail you are learning about that in part C. So we will learn introduction to nuisance, public nuisance, private nuisance, and remedies. Okay, the concept is not very vast, but whatever cases are coming under that, to understand the concept, we will go through in detail. Then strict and vicarious liability. Introduction, strict liability. So strict liability and vicarious liability is also the concepts those you have learned in your university days. So we will recall this concept. It's also quite interesting, and you have to identify and categorize this as well. Like, what is the liability that is falling upon the person who has done the wrongful act, and what is the extent of liability? What is the type of liability? Okay, and why it is strict liability and not vicarious liability. And they might also give you, looking at the sample paper, it looks a little bit scary. I know, like so many fill in the blanks and also many things they have given. And sometimes they might give you multiple choice questions or direct one marker questions. So we should be ready for any sort of questions. So what we will do is we will understand the concept so well that whatever they ask, once you cover entire syllabus, there is no scare of whatever form of questions they ask. You should be having the answer, and you should be having the confidence to answer that particular topic. So we are not going to leave anything, and we will understand the concept also with the mindset that ye exam mein puchenge to how will I answer this. Okay, and of course when we are doing question and answers also, we will cover a lot of things. Now, then the part E talks about negligence. Negligence may introduction, then elements of negligence action. So negligence is a concept where the concept of duty of care. These are also you have learned in criminal law. I think, Hinal, have you written criminal law exam so far?
No, I haven't.
You haven't. And did you start studying for it?
No, I haven't.
Okay, no problem. Then for you it will be ulta. Like when you're preparing for tort, you're learning these things, and when you're reading the same wordings over there, आपको context मिल जाएगा. So, but anyway, we have learned this negligence concept at least in India when we are
Yes.
we have done our LLB, right? So
Yeah.
none of these concepts should be alien to you guys. Okay, so पहला वो डर निकाल दो, because I know NCA exams are sometimes be scary when they change the syllabus and we don't know what to refer, how much to refer, what to do. So many questions are there. I understand that, and वो थोड़ा 40% of डर is good, but बाकी 60% should be like वो confidence, kind of self confidence भी चाहिए. And I'll try my best to give you that confidence by discussing all the concepts, and until you get the clarity of the concepts, we will cover them thoroughly. And yeah, so but don't be afraid of any concepts. I know there are number of concepts, but don't be afraid of it. These are things that you already know, and the cases are something new that you don't know, and but they are interesting to learn, interesting to remember. So don't think that you're preparing for November exam, at least for until we complete the syllabus. Till then, you just get the idea of, like train your mind to think like, oh, I'm learning something new for my just pleasure of understanding. Exam के बारे में थोड़ा भूल जाओ for a few days. I will remind you later. But like for now, just forget about the exam pressure and everything else. Just think that I'm learning something new and I'm interested to learn this concept. Okay. Then we have elements. In the elements, we have duty of care and the standard of care of a reasonable person. So negligence में ये सारे concepts are very, very interesting and like very it's there, like how basically a person should take care of somebody. And if I'm if I'm supposed to take care of somebody, and if I don't, then that becomes a tort as well. Of course, negligence hai, and there are criminal negligence also. If I negligently, like if I drink and drive, that's a criminal negligence, right? And whatever is covered under the criminal law or statute, usko hum change nahi kar sakte. We can't change them, and those will be interpreted accordingly, and the law enforcement will come and like arrest those people. Okay, but we are learning those things for understanding, and we will do once we know in the introduction chapter that what is the difference, the key difference. So they are important. That's why I wanted to show you the entire syllabus first. So we will be a little more serious in the introductory chapter as well. So here you can see negligence is there, and we need to understand. So whole big chapter they have given here. Voluntary assumption of risk, defense in negligence. So हर जगह आप defense भी देख रहे हो, यहाँ पे remedies are there. So everything we have to find out. Then the sixth part is tort liability of public authorities. So till then we were saying like in a private section, kind of like person to person, right? Then what about the public authority? Are they not liable for any tortious acts, or how does it work? So we will learn about this as well. Tort liability of public authorities, introduction to that, special rules with respect to that, and negligence of public authorities. When the negligence that we learned in the previous chapter that happens by the public authority, then what happens? And misfeasance in public office, other torts. So overall, now we have seen the entire structure of the syllabus, and tell me, like, how do you feel about the entire sections of the syllabus, how they have divided it, and the concept that you're seeing, how are you feeling about it?
Like I saw like I think 3 chapters are like lengthy. Apart from that, rest are like not that lengthy.
And I
Yeah.
think these topics
three
like we
chapters.
have seen in India also. So like it is somewhat similar to what we have learned for torts in India. Like it can be different, but yeah, the concept names and everything, it's somewhat that I somewhat remember kind of thing.
Yes, exactly. And that confidence I need you to have. So these are things that we already know, and we are just going to explore it little bit more with respect to अभी देखो ये McDonald case हमें नहीं पता है ना, and what is this OJ Simpson का ये legal history, what is that, we don't know. So the resources that they are telling us to read or go through, that we will go through. And there are a lot of cases now. For example, ये जो note 8 है, and this thing page number 829 to 853, out of that out of those pages, if any cases are mentioned, that is also we have taken in the notes. Okay, so sometimes the students get confused. अरे ये तो syllabus में है नहीं, but it is there in these pages. Okay, so syllabus में है नहीं मतलब यहाँ पे they don't have to list all the cases that you are supposed to study, but if it is there in the prescribed material, you are supposed to know those cases.
Vidya, that O.J. Simpson, is that the celebrity case or it's different? Like, there's one like O.J. Simpson, like from Hollywood, that is like very famous.
Okay, yeah, that is O.J. Simpson. 1 second. The murder case, no?
Yes, yes. Of his
Nicole Brown Simpson.
wife
Yeah, wife and I think son.
and like her boyfriend, I think.
Yeah, Nicole Brown and her friend were
Yeah.
found stabbed to death. Yes, correct. Yes, the same case.
Okay.
See, again, interesting, right?
Yeah.
Yeah. So we have in the first section, we have 27 pages, and we will see how many we can cover today. And yeah, there will be a lot of reading, but let me know if you get any doubts. I will stop here and there and explain what we have read. But one reading of entire study material is very, very important for, exam, right? So in section A, Introduction to Torts, first chapter is the concept of torts. So tort is regarded as the legal wrong or breach of obligation one person owes to another. So it's basically what is it? A legal wrong or a breach of obligation. So you might have obligations under a contract, you might have obligations orally, okay, or you might have obligations by law. So it could be any form of obligations, but these are either a legal wrong or a breach of obligation one person owes to another. So that becomes a tort. So it's a general understanding of tort. There is, however, a distinction between public wrong indicated in criminal law. So what is in criminal law? There are wrongful acts. They have categorized it as crimes. But what are those? They are public wrong. And one key difference that we can see here straight away that these are public wrong. That means tort has to be private wrong, right? It is being wrongful act has been done towards me, not towards the public. Abhi crime hota hai na, like any crime is seen as it is the act against the state or act against the province or the government, basically. So in England and in Canada, basically, we will see these public wrong are done against the society, and that's why they are prosecuted by the Regina, that is queen. So in case if the crimes were not considered as public wrong, then the victims parties, personally, they should have, hired a lawyer and they should have represented themselves. But no, criminal cases are why they are prosecuted by the queen, because they are the wrongful acts, they are the public wrong done against the society. Now, and the punishment is also imposed on the wrongdoer. On the other hand, tort law deals with wrongs committed against the individuals in which the case, the wrong is prosecuted by the individual as the plaintiff against the wrongdoer as the defendant. So one side, who are the parties in a tortious, what is that, plaintiff? So we can say tortious action. We can say one party is plaintiff. It is the person against whom the wrong has been done, and he is filing this suit against the wrongdoer, and he is called as the defendant. And we can see here the tort law deals with the wrongs committed against the individuals, in which case the wrong is prosecuted by the individual. So this is the key difference. If somebody asks you for one question, 1 mark, okay, what is the difference between tort law and the criminal law? You can say the criminal law deals with the public wrong indicated in criminal law where the wrongs have been committed against the society and prosecuted by the queen. and the punishment is also imposed on the wrongdoer. And on the other hand, tort law deals with wrongs committed against the individuals and the case, and in which case the wrong is prosecuted by individual only. So personally, we had to file the suit, and
Vidya,
they are
can
called
you
as
give me an example as to one difference, like example as to what will come under the criminal law or the tort? Like, suppose tort
yeah,
is
I can
against
give you.
individuals, so can it be theft? Like, theft is only against the individual, so he will file a case against person who has committed the theft.
No, no, no. Theft becomes now, see, whatever crimes already given or covered under the criminal code, those
Okay.
are categorized for a reason. Okay, whatever is already written in the law. Tort is almost, I feel that something wrong has been done with me, even though it is not written anywhere, right? If I have a case law, that's well and good. Like, kutta bhonkne ke liye basically, I can say like that is a tortious liability, right? Because, I mean, there's a dog, and my neighbor has a dog, and that just shouts. Okay. Now, of course, some building has bylaws and all those things. Now, consider there is nothing. There is no bylaws. There is nothing written in law. It's not covered anywhere. Then it comes under the tortious liability. But on the other hand, if I say mischief is covered under the criminal code, and mischief is basically, आप किसी के property को जाके like पत्थर मार रहे हो, or like, something that you do mischievously to a person's property, that is covered under mischief under criminal law, and that cannot be said as tort because that's already a criminal act and it is defined properly. उसके लिए punishment prescribed है, so we can't change the criminal law. Whatever is not covered and whatever is specifically not categorized as crime, वो basically बच जाते हैं and they filter out to be uh, you know not a criminal offense, and out of those we have to pick the whether it is under tort, or if it is already covered in the contract, then we will go under contract law. So we can go under contract also. And further, we will see more of distinctions. But अभी के लिए समझ में आया like basic difference?
Yes, समझ गया.
Here, the focus is on the plaintiff's loss, and where the defendant is found liable, the plaintiff may be awarded remedy that is commensurate the wrong. Commensurate the wrong. Basically, here the focus is on the plaintiff, and we see, in criminal law, what happens is somebody commits theft. So it's basically seen as a criminal offense, right? So in criminal offense, what we see, okay, it happens in a public place. For example, shoplifting happens. Okay, shoplifting happens, and I am also scared, na, कि हाँ उस जगह पे like now shoplifting may happen, and like somebody steals. Somebody, thief is basically doing that act not against only one person or that shop. It's basically against the society. It's considered as that, and they will not be seeing ki in criminal cases the punishment will not be seen that the person is getting the damage. Of course, that is also covered, one of the remedy, but the main focus is to rehabilitate and stop that particular crime from happening again against the society. But here it is seen, the focus is on the plaintiff's loss, and what they do, they'll be like, okay, if the defendant is found liable, then the plaintiff may be awarded a remedy that is in proportionate with the wrongdoing. It won't be like, okay, like somebody, trespassed my property under tort, let us consider like that, and then I will be not given $1 million for it. Okay, they have not done any damage to the property. I'll not be given, basically a huge amount for that. So they will measure it and give the remedy accordingly. In the same light, some private wrongs may fall outside torts and come within the ambit of law of contract as well. How? We will see. So there are significant overlaps between these areas of law. The same set of facts may lead to criminal prosecution as well as a civil claim in tort. The same situation may give rise to liability in either tort or contract. So same facts or same situation. This is where your confusion would be in the exam. You'd be like, okay, whether it is tort or whether it is contract, whether it is tort or should I go as per, this is a criminal law. So what should be the case? So we will understand these distinctions as well. Now both tort and contract share the same basic structures in terms of primary and secondary obligations. Now there are these two words that we are seeing: primary obligation and secondary obligation. What are these primary and secondary obligations? First one, primary obligations tell people how to act, while secondary obligations provide remedy where the primary obligation has been broken. So पहला वाला जो है primary obligation that tell people how to act, what I am supposed to do, right? How to act. That is one obligation. That's why it is called as primary obligation. How I should act. Secondary obligation is the remedy where the primary obligation has been broken. Now I'll give an example. Secondary or provides when that is broken. Okay, I'll give you an example. Now, under the there is an understanding between me and another person that I will keep watering the plant. Okay, so my neighbor basically goes out of station or something, and she will ask me to water the plants. Okay, so that is my what is my primary obligation? My primary obligation is how I should act. I should take care of the plant. Basically, I should water it. I mean, I don't know how many times a day they water the plant. Let me just consider as once a day. Okay, so once a day I should put water. Now, what happens if I don't do it? Then the secondary obligation says, what should be the remedy? I should be, held liable. Should I compensate her for the, plant, if the plant, something happens to plant dies, or like, or if I put more water, basically, that also is wrong. So the secondary obligation basically says when the primary obligation has been broken. So if I'm not watering the plant, that means the primary obligation has been broken. So that time, what remedy should be given to that person? That is considered in the secondary obligation. So remember these words, okay? And we'll see like how it will come up. A victim is generally allowed to explore all available options to seek remedies. Example, so victim here in tort we say plaintiff when they go as per the tort action, but generally the person who is affected, victim, right? So victim is generally allowed to explore, generally allowed to explore all available options to seek remedies. So option किसके पास है? Choice किसके पास है? The victim has the choice. For example, in tort and contracts at the same time. Now, under both the places, both the laws, they have a particular remedy. In contract also they have a remedy. Tort also they have a remedy. Under what they have to, file the action or file the suit against the defendant. That makes that gives the choice. That choice is actually given to the victim here, but he can only choose a remedy in one, as he cannot be allowed double recovery. So law is also smart. Of course, it will give you choice, but it will not be like, okay, पहले मुझे देखने दो, like I will just see if I can go through, tort, or can I go through by contract? If that doesn't work, I'll go here. No, double jeopardy is there, no? So double recovery is also not allowed. So basically, what has to happen? They can only choose one remedy, which they have to follow, and they can't get double recovery from the same act. Same facts, same set of facts cannot have double recovery. Notwithstanding shared similarities, tort and contracts are also different in many respects. Namely, Now this you can mark it. You can say, you can mark it for the difference, right? So the differences between tort and contract. इसको mark कर लो. There are 3 points that we discussed first. So first one is the source of primary obligation in tort arises from law, while in contract it generally arises from the agreement between the parties. Take some statutory impositions. Example, Sale of Goods Act. Okay. Provided that if it is not already covered under any statutory impositions, for example, Sale of Goods Act, वगैरह. So, many a times now we see that contract is not entirely as per the wishes of the people, right? You and me getting into a contract, we also have to adhere to so many laws. Now that depends on what sort of agreement that we are doing. If we are, getting into real estate sale, then there are laws which recognize, certain rights of yours, certain responsibilities of mine, and there has to be, certain formalities to be fulfilled before we do things, and certain actions that you will have as per the statute only. It need not be that I have covered or I have not covered it. Still there is, a statute that says, yes, she can file a suit against me. That is also there. So there are some exceptions, but generally, on the general sense, you can say the primary obligations and secondary obligations. What are those? Primary obligations are the thing that is saying the obligation basically that says how to act. It's not the remedy, it's the act, how to act, right? What are my obligations? How am I supposed to act under this particular situation, under this present situation? Now, that is coming from, in tort, it is coming from law, and in contract, it is coming from the agreement between parties. Whatever the law is, under that only, there will be some additional points that, that both the parties in the contract has to have a meeting of mind, right? And if you don't agree, then there is no agreement in that particular contract. So we both have to agree for certain things, and from there itself, the primary obligation comes. Of course, the law will be there, which gives you certain statutory obligations as well. But other than that, when you are supposed to pay me that amount, when you are supposed to do certain acts, when I'm supposed to deliver my, goods or like whatever it is, service or something, that is decided by whom? Decided by the parties. So the primary obligations come from law and tort, and in contract it comes from agreement between the parties. The doctrine of privity of contract applies in contract as no outside party can sue based on a breach even if affected. In tort, generally parties can sue one another even if they are not, even if they are complete strangers. So contract में क्या होता है? You and I are in a contract. Now I will tell you who is there. Priyank and me. We both are under a contract. Now Hinal is a third party. Now, if I don't deliver a particular product by 20th of October to Priyank, then he can file a suit against me. Okay, I have primary obligations towards Priyank only as per that particular contract. And Hinal cannot file a suit against me for that particular matter. However, in tort, what happens if I do certain acts? You don't have to be known person to me. If I do something against you, you can file a suit. I need not be your friend or under a contract or any relation need not be there. You can file a suit against any stranger, complete stranger. That is another difference that we see.
So basically, Vidya, the
Then the
example
third
you
one.
gave right now, like you and Priyanka are into contract. So basically, I can't sue you people because you are in a contract. It is only Priyank who can sue you. But in torts, if I am not a party to a contract, then too I can sue you if something wrong has been done, but even if I'm not a party.
No, there is no contract. In tort, there is no contract, first of all.
Okay.
And if I do some act, if you are the victim, then you can file. There need not be any prior relationship between us.
Okay.
That is the concept. There is a concept of doctrine of privity of contract, which prevents basically people who are stranger to contract to file a suit against the parties in the contract. Okay.
Okay.
So that is the basic concept. So they are saying that is another difference between tort and contract. And in contract, we have this where third party cannot sue, but third party is a stranger, no? Is a stranger. So basically, that part of stranger is here. You can say the difference. In contract, you have to know the person. You have to be familiar with the person. There has to be a prior agreement and prior understanding of primary obligation. उसने दिया होगा आपको obligation, but tort में ऐसा पहले से obligation नहीं है, but it's sometimes it's understood. Sometimes you can anytime you can basically complete stranger also be a party to a suit because they have done something. And you need not have a prior relationship with them. Good.
Okay, got it.
So the third difference is while compensation is available in both tort and contract, compensation in tort looks backwards and seeks to put back the victim in the position he was before the breach. So basically restitution. You can say the concept of restitution, you can just write it here. So compensation is both in there available in both contract and tort. That's a similarity. But how it is different in compensation in tort looks for restitution only, whereas the compensation in contract looks forward and seeks to put the victim in a position he would have been had the breach had not occurred. Usually in contracts we have clauses for that as well, right? So that says if this particular breach was not done, then I would have so much profit, right? If I had, delivered a particular goods, a bunch of pens or something to Priyank by 20th, you would have written in that particular, using that pen, you would have written a particular essay within the due date, and he had a chance to or like he was supposed to submit it within a particular date, and उससे उनको कुछ profit होने वाला था. Either he completes that particular assignment and completes the course, or he might be getting a particular profit or getting paid for it, something, right? So basically he would have been in the position. आगे का देखते हैं, like they look forward and see that where that person would have been if that wrong had not happened. But in tort, no. Tort is like basically they're like, okay, you stay where you are, where you were supposed to be. How it was before such nuisance or like anything happened, right? So peace is to be maintained. It's not that, giving them a boost and like, putting them where they were supposed to be. They are usually put, they look backwards and they seek to put the victim in the position that he was before the breach. Is this clear? So under the syllabus, we have three difference of tort and contract could be asked in a, theoretical manner, but basically it should be for the understanding, clear understanding. And isko dekho ki for tort what they are saying, okay? Consider the things that they're saying towards the for the tort, because we are writing tort exam, not contract. So we'll focus on tort aspects and traits wherever we are learning one point. Just make a list of them or like just underline and keep a note. So that's introductory part. Now coming to the first part, that is nature and history of torts. What is the nature and how this history of torts has developed? Historical background we will learn, and this may be a bit boring, but from the exam point of view, not so important. But we will have for our knowledge purpose, we will read through. The history of tort law is that of the separation of public and private wrongs, leading to the emergence of the general body of civil wrongs. Originally, during the Anglo-Saxon age in England, there were no divisions between crime and tort, and any wrongdoer was required to pay a bot to appease the um, wronged clan and pay wide to the king for breach of peace. Basically, like a compensation was given to the king for breach of peace, and they were supposed to pay kind of like a damages to the to appease the wronged clan. So, Anglo-Saxon age of England. Do you guys know any idea what is Anglo-Saxon age in England and how it was? There used to
No
be like
idea.
no idea, right? It's okay. Like we don't have to, I think. But if it keeps coming up, I'll also dig deeper a little bit about the background and I'll tell you. Okay. But so far it doesn't seem that important. This was the practice in until practice. This was the practice in place until the normal conquest when William the Conqueror imposed a uniform set of laws throughout England. So, who did the uniform set of laws throughout England? Norman conquest. William, William the Conqueror. Okay. Uh, yeah, this body of law came to be known as common law because it was common, uniform among everybody, right? So, अलग-अलग ग्रुप के लिए अलग-अलग रूल्स वगैरह नहीं थे, एक कॉमन लॉ आया with its procedural formality of commencement of action via writs issued by chancery clerk. Chancery, there used to be chancery courts also. Chancery courts are basically the, place where they were um, dealing with the cases on the equity basis. Earlier days, जैसे आप राजा महाराजाओं के टाइम समझ लो इंडिया का भी it used to be that only, na? Like they used to be living on principles rather than the law. And then the law came and personal laws, of course, like different laws were there. And based on those, but king used to always make the decision on, his discretion. He had a huge discretionary power. He had the prerogatory rights, right? He could decide based on the circumstances. आपका जो case है, whatever facts you had presented before the case, before the king, that he would have given you, 1 day in jail, for example, and but for me, he would have given 10 months in jail. So even for the same set of facts, but your background is different, my background is different, should have had kind of a epiphany, or like he had whatever, like according to their discretionary power and equity, trying to do the just and fairness, they used to do that. But later there was civil law and common law, dono mixed hoke, equity and law kind of mixed. And now in court you can see the how the court works now. Now the court um, takes the authoritative principles and laws, statutory laws, and equity also, but to a very lesser ratio, equity is taken into consideration. The discretion is still there, but they do have some restrictions to how to, appease that. Then these were the standard pleadings, and any allegations of wrongdoing must fit into an existing writ. So writ, यहाँ पे हमें थोड़ा writ के बारे में we have to learn what are the writs that was available for tort liabilities. Okay, a plaintiff who could not get his claim, a plaintiff who could not get his claim within the scope of an existing writ would not get his grievance heard unless on rare occasions when chancery officials prepared and issued new writs. I said, no, they have the discretionary power and prerogative power. They can give this. Okay, whatever. Now, for example, there are 4 or 5 writs. Okay, there are 5 writs, for example, used to be in the phrase. Then, if your grievance is not coming under those, written 5 things, then it will not be considered as a application or as a grievance. So, unless some rare occasion, chancery official prepared and issued a new writ. Okay. So it used to be very restrictive. We can see the situation before was very restrictive. पहले तो in the beginning it was criminal law, public wrongs and private wrongs were basically considered as one, and they were having general body of civil wrongs. But later that also divided and common law was introduced, and the chancery clerks, we see that chancery officials had the power to prepare and issue new writs, and unless your grievance is covered under a particular writ, that was not considered to be heard initially, unless that was coming under some writ that the chancery officials prepare. Initially, the only complaints heard by the king were violent acts done with the force of arms and against the king's peace. That is, vi et armis et contra pacem regis. Okay, so that is the Latin statement or something, but you can see the meaning is violent acts done with the force of arms and against the king's peace. So now what we say, the society, public interest. So earlier we used to say that king's peace, or the king ka like peace of mind ko consider karte the, but kings and subjects, those used to be the days, right? So now it is the public interest, or you can say the society. So wrongs like assault, battery, trespass to land, taking of goods and other causes, we now know as torts, were grouped into family of writs known as trespass. So ये सारी चीजें trespass के अंदर आती थी. All these things will were coming under trespass and other causes. Now these are all torts, but they were all categorized under trespass earlier. Wrongs like assault, battery, trespass to land, taking goods of another, taking of goods and other causes. Till today, these writs are still referred to by their names as in the original writ. Till today, these writs are still referred to by their names as So whatever they used to call earlier, still they are called the same, but of course, changes would have been done. Therefore, to bring a complaint within the limited available writ and to have access to the king's court and jurisdiction, plaintiffs had to plead vi et armis in their facts, even where no force or breach of peace was involved. Yeah. So basically, it is like, the facts are slightly tweaked and said that ye with the arm use wala hai, force of arms hai, because they wanted it to come under the particular form. Now, what happens? We do that thing even in the present day. Now everything is online. For example, if you might have definitely come under this particular situation. So think where when you were filing a particular application, there will be some things compulsory point rahega, right? Even though you are not coming under that category, you have to click on that button, वरना वो complete नहीं होगा form. So sometimes even if it is not your point, but still you will try to include it under your application so that already available, like kind of like you can say mandatory things उनको करना पड़ता था. Eventually, however, the king assumed jurisdiction over most civil wrongs, and by 1300, there was no need of further plead vi et armis. So after that, most civil wrongs were covered under that, under the king's jurisdiction, and they need not be having this particular pleadings. So this was the earlier history, you can say, the olden days that used to happen. Now, regarding the vi et armis, we know there is this one trespass vi et armis using the arms. So that is also a writ. So let's see. Though the writ system still remained, they developed three visions of it as follows. So abhi ke liye, what are the developed three visions of the writs? The writ system is there, but it's developed. So developed writ system, we can see there are three. trespass v et armis when the defendant's conduct affected the victim's person. So now the meaning is different. Meaning is different and the ambit of application is different. So you can see what is the meaning of v et armis. Et armis is when the defendant's conduct affected the victim's person. Person means body, the person himself, not their effects, not their items or not their property or anything else. Themselves. It's affecting them. And we saw in the syllabus as well, it is covered under the whole different section, right? So they have covered assault, battery, everything. Then trespass de bonis asportatis. That means when the defendant improperly handled, damaged, or destroyed the plaintiff's goods, items, personal effects, goods, movable hai, right? So chattels, you can say, those are called as chattels. So trespass de bonis asportatis is with respect to goods. Armies, you can say, arm is, on the body. So like that, you can remember its body, like person. And asportatis bonis goods. Find a, word that you can recall. But otherwise, highlight करके भी रख सकते हो. You can just see it's not a, it's open book exam, so that's also fine. But usually I find some word to remember myself as per that is. It sounds like an item. So
You can use
good.
port, right? Port and goods.
Oh yeah. Port and goods, yeah. Nice. Then trespass square clausum fragit. Clausum fragit when the defendant improperly entered into the victim's land. Fragit. Clausum. Quare clausum. Quare clausum fragit. इसको हमें करना है land का related. So when the improperly entered into the land, victim's land. So there are three things. जो syllabus में भी हमने देखा. See, when you see the syllabus and read this, then it makes more sense and we can, basically connect. Okay, हमें अगले chapter में like we will get to see that. And इसलिए now with respect to writs, what we are learning, it's going to be applied over there because what is covered under what writ we are learning here. These are very introductory चीजें. Okay. All these three forms of trespass required proof that the defendant had used force directly on plaintiff's person, goods, or land. So, what is required to see? The defendant used force. That is important to show directly on the plaintiff's person, goods, or lands. जो भी writ के अंदर होता है, whatever writ you are filing, under that you have to see the elements are matching. Then, land, otherwise the king's court would not assume jurisdiction. So if the jurisdiction has to come there, then the force should have been directly applied by the defendant on that goods, person, or land. They were all actionable per se without any proof of actual damage. They were actionable per se. Okay. What is the meaning of actionable per se?
Like we usually use it like to replace actually, right?
So basically, per se means by itself or through itself. Okay. So because
So,
we will learn a lot of different terms, and whatever is written in italics, ना वो हमें समझना चाहिए. I think for tort law, we need to understand all these writs का जो भी meaning है या फिर other words like in rem, all those things and all will come. That's why per se is like on its own or through itself. So they were all actionable per se without any proof of any actual damage. That means if you can prove on its own means if you can show that the defendant had used the force directly use karna, that is sufficient, then damage need not be proven. Like for example, if somebody pushes my okay, so there's a box, that's my box, okay, and you just throw it, okay, throw it like from the table like to down, okay, उसमें damage हुआ कि नहीं, like something is broken or not, that is not seen, that need not be, there need not be any proof of any actual damage, but the fact that you applied force to my goods basically, that is sufficient. You can see how little they needed to prove, right? Nonetheless, the narrow scope of these writs necessitated the creation of newer writs that could accommodate defendants' acts that were outside these three varieties of writs. But what was the problem? These three writs were only trespass, right? But there are lot more wrongs that are there in tort, but they were not covered. So, a narrow scope was there. It was having narrow scope because only three were there, and they had to allocate more writs as such. This led to creation of writs of trespass on the case. What is writ of trespass on the case? Which covered harm that is not by force or directly, not inflicted directly or by force. Okay,
Vidya,
they
your
were called
voice is
as writ
breaking.
of trespass on the case. Okay, there might be internet issue. Now, is it clear now?
Yes.
Okay. So yeah, so I was saying this led to creation of, because the narrow scope of only three available writs, it was not covering everything. So they created this writ of trespass on the case, the kind of a general thing जो भी इस case में हो उसका decide कर रहे थे, and that was to cover harms that were inflicted not by force or directly. It was not not inflicted directly on the goods or of force, person or land, or it was not by force. ऐसे ही हो गया. So with this new writ came the requirement that the plaintiff can only succeed if she can establish that she suffered damage, unlike the previous writ system where only the proof of force was required. Now, what is difference between the earlier three writs and the writ of trespass on the case? Earlier three writs they had to only prove the force that was done applied directly by the defendant. But in the later writ of trespass on the case, they had to prove actual damage. Okay, that they have suffered the damage and they had to show the damage. They had to succeed in showing the damage, unlike in the old system. However, by the 19th century, judges began to develop the idea of fault or moral blameworthiness also. So later they came up with another, concept of fault. So you can say 19th century means judges began to develop the idea of fault or moral blameworthiness. They began to require proof that plaintiff's loss was caused by the defendant's intentional wrongdoing or carelessness. So they made these distinctions. Fault kiya. Then they said moral blameworthiness. Now they began to require proof. That means they started asking for proof. So you can see the development, right? Like earlier only force was required. Then they saw, like practically while applying, there might be so many people, just by proving force, they won the case, and the people independent, they lost the case. So the law keeps changing for the good. So here the changes you can see. So they required the proof that the plaintiff's loss was caused by the defendant's intentional wrongdoing or carelessness. ऐसा ही नहीं कि either wrongdoing intentional होना चाहिए या फिर negligence or carelessness होना चाहिए. Carelessness is also like I need need not think that I need to make you suffer, but just because I don't care, that also can be, that also can be reason for your loss, right? So that is also there. Eventually, the writ system was abolished by the Judicature Act of 1870s. So, first legislation that we are seeing is Act. Judicature Act of 1870s. So, what was abolished? Writ was abolished. अभी सिर्फ concept है, same concepts are there, but the writs are abolished. Then what happened? With this abolition, with similar legislation in other common law countries, including Canada. With this abolition, a plaintiff does not have to fit his claim into an existing grid. So, abhi kya hai? After that, what happened? They said that now you file anything you want, basically, right? You don't have to fit into any existing grid. Apna case batao. You tell your case, we will file a suit for that. A case would be heard once the facts of his case justified any relief under any recognized cause of action. Still, they will not be like, okay, you bring on anything. You bring on the case, we'll see the facts. If it is justified, like, they'll see a locus standi. Locus standi, they say, whether you are eligible to stand for this particular, before this particular court, asking for a remedy that we can give. There is the jurisdiction, there is the, proper structure of the courts, everything. So, if it is justified that any relief under any recognized cause of action, if it is covered, then okay, that is sufficient. By the end of 19th century, academics and scholars began to call for the recognitions of tort as a distinct branch of law. अभी तक क्या था, वो सिविल में कहीं घूम गया था. Like it was mixed under the civil law. Okay. Now they started to see tort as a distinct branch of law. Of course, the scholars and academics are there for, proper thinking of these kind of things, right? And make another particular subject for us to study. So 19th century comes and this happens. Now, writers such as F. Pollock argued that the law of torts was based upon the single unifying principle that all harms were tortious unless justified. So, इस writer ने क्या बोला? What did he say? He's saying that all harms were tortious unless justified. अगर आप उसको justify नहीं कर सकते, that means any torts, any harm done is tortious unless it is justified under any, with any defense or under any law authority, anything. J. Salmon argued in contrast as to whether there was a general principle of tort liability and contended that tort law was merely a patchwork of distinct cause of action, each protecting different interests and based on separate principles of liability. So here in this paragraph, basically you see different scholars and academics, unka apna views. Okay. So here this another person is asking that is there any general principle of tort liability that is contended that the tort was merely a patchwork. According to him, he's like, no, it's not a separate branch. It's a patchwork thing and patchwork of distinct cause of action. Like सबको ऐसा मिला के एक जगह पे आपने डाल दिया. It is not all having a general principle of tort liability. नहीं दिख रहा है मुझे. According to that stand. Even in the courts, the debate as to whether there is a general theory of tort liability persisted in the dilemma was whether, confronted with new claims in the growing area of negligence, the tort liability should be expanded, and if yes, on what ground? So even in the courts, the debate used to come. ये जनरल थ्योरी है, टॉर्ट लायबिलिटी के लिए. इज देयर एनी जनरल थ्योरी नाउ, फॉर एग्जांपल इन कॉन्ट्रैक्ट और क्रिमिनल लॉ और any other law, civil law, we see now like there's a common background, like the elements will be there. Like we say in criminal cases, actor says when they prove kar do, then beyond reasonable doubt, then yeah, done. Then there are defenses and all. But tort mein kya? It's ever growing, right? Like and we are talking about not 2024, we are talking about 19th century, earlier 19th century, jahan pe it was, they were expanding the different form of like from 3 writs, it went to, 4 writs. Then they said, okay, abhi writs nahi chahiye, abolish the writs. But then still, the concept is still growing and new actions were adding to the tort. Now, on what ground basically we should do that? We have to see Donahue versus Stevenson. Donahue versus Stevenson, 1932, where Lord Atkin suggested that the code will expand the scope of recovery, at least in the tort of negligence. This debate has continued till today, and the courts will consider legal, social, economic, and philosophical circumstances prevalent at a particular time to consider whether to expand or narrow the scope of liability. मतलब liability का बारे में बात करें, they're talking about liability, not about punishment or like anything else. Like liability, how much am I liable for hurting you, and what and all should be considered. So for negligence, they are, as Priyank rightly said, some chapters are little more, right? So you can see trespass and negligence, and now you see why it is, expanded so much, because it is needed. It is needed to have certain grounds, have certain, defenses, to clearly state those concepts because they are core of our tort law. For instance, if the courts fear that liability is killing the insurance industry and may lead to crisis, it may narrow the dependent duty of care. If it is killing the insurance industry, that means they're saying they may narrow the dependent's duty of care. The dependent was supposed to take care of a particular person, item, or anything. Then, if they don't, then what happened? That person has a insurance. Of course, in Western countries, everybody has insurance for everything, right? So if the insurance, of course, that person, extent of liability or extent of duty of care. Duty of care is what? It's a primary obligation. It's an obligation, right? It's a primary obligation. I'm supposed to take care. And if I'm not taking care, then I'm supposed to pay. So if such situations arises and court thinks that the liability of that defendant, if I say the person is liable for 100% of the damage, he was supposed to take care, he didn't take care, now you pay up and restitute the person, right? If we are feeling that no, the burden will all fall on the insurance of that person, then then the court may narrow the defendant's duty of care. Whatever their obligations were there, na, you can say that no, it's okay. Like they were supposed to take care, but itna bhi nahi hai. They can narrow it. Narrow means like make it very thin line. Conversely, the courts may expand the scope of liability if there is a concern that the insurance industry is unduly profiting at the expense of the injured customer. That is also happening. So it depends, circumstance to circumstance. The court may change its thinking and application of the concept. And the liability is, narrowing and expanding based on the circumstances of the basically insurance industry also they are seeing, and also consumer also they are thinking. Okay, that was the historical background, and we will now go to historical roots of trespass and cases. Now, here we will further examine the history of emergence and the difference in application of the two forms of action. What are those? First is trespass and second is trespass on the case. Earlier we saw no trespass and trespass on the case. There are 3 topics under trespass, 3 writs, but there are particular trespasses, and trespass on the case is like general one. Now, what are these two forms of action? This is a follow-up on our earlier discussion about about the about the topic. Remember, we noted that the writs, same thing.
On property, person, and all that.
Yeah, same thing. Yeah. So we saw trespass had on person, property, that armies and port, and one was frugis, something was there. So they
Square,
said there was
something.
basically on the land. Yeah. So trespass involves trespass against the person. Action on the case involves trespass against anything else that may be actionable but is yet to be established category. So trespass on the case is basically there is a trespass, of course, but category is not yet decided whether it is a person, it's a land or goods. Pata nahi. Don't know yet. As earlier stated, initially, writs of trespass could be litigated on the royal courts only if the plaintiff argued that the defendant used force and arms. Hence, the title Trespass Viet Armes that encompasses the three versions of trespass at the same time. So, to enable the cases to be heard, the plaintiffs falsely allege force and arms under one of three versions. For example, Rattlesden versus Grunstone, 1317, which was merely a dispute on allegation of adulteration of wine with salt water. तो वाइन के लिए वाइन पे उन्होंने salt water mix कर दिया था. तो इसमें आम कहाँ है, force कहाँ है, right? In the writ, however, and to allow for matter to be heard in royal courts, the defendant was alleged to have with force and arms, namely with swords and bows and arrows, drew off a great part of the wine from the aforesaid tun. Instead of the wine so drawn off, they filled the tun with the salt water so that all the aforesaid wine was destroyed. So these things were, changed. Like the facts were changed because they wanted the matter to be heard in the royal courts. Royal courts में serious matter ही लेते थे, right? So they wanted it to be serious. So they changed the facts. Another case, the turning point was the case of Walden versus Maris Shai, and it was 1369, where it was alleged that the defendant had negligently treated the plaintiff's horse. Okay. The defendant had negligently treated the plaintiff's horse. The court of common pleas accepted that in such a situation, an allegation of force and arm within a writ would not be appropriate. So when they said that, it was negligently treating a horse, it is not having a force and arms. So this writ would not be appropriate. This marked the recognition of the emergence of writ of trespass on the case, wherein the plaintiff does not have to prove the force and arms to bring the writ. So this was the turning point. Walden case was the turning point where they said that, acha. So now this is where we understand that, simply for bringing the suit, they are changing the facts and all. No, by then they were also like tired. So they are like, okay, now you don't have to prove. So we don't have to prove. The court said that. Okay. So the court said that in this case, they said that, okay, now you don't have to prove the force and all. You just have to say that, the new category where they had to say trespass on the case. Now that writ was emerged in this particular case. So this becomes a landmark case for you. The emergence of writ of trespass on the case came with Walden case. So, in addition to the historical significance, the above is basically just another method of classifying tort which has survived to this day. That is, whether the harm to the plaintiff has caused directly or indirectly. So, with force or like just some without force also harm has happened. Basically, you have to prove the harm. So later they got this and they said that that is a change that they have done from Walton case. Therefore, wrongful conduct can generally be actionable in the following manner. So, Abhi, what are the two categories that we have? Two forms of action. We have it can be actionable under writ of trespass on the case. So, under this writ system, the plaintiff must choose which writ to use and choose correctly. Otherwise, she would lose even if the court thought that the defendant would have been held liable had different writ been chosen. So it's basically that, no, like if you whatever prayers you're asking, so same thing will be given. Even if the other things are available, they won't be given. That's why in the prayer we kind of add that any other, any other compensation or damage or like any other relief could be given, like that we add. So I think that was the first thing that I learned in moot court, and the judge was like, okay, you didn't ask for this, so we can't give you this. So I learned in moot court. So here I think I can apply the same thing when I say, if I ask for a particular writ of trespass in at armies, so person wala pucha, so then we can't like later say that no, it was on the case it was different category itself. So on the case hai to we have to, if it is any other category, then we have to specifically say it was trespass on the case. Then later we can't change. Just because we think that the defendant would have been held liable if it was a different writ was chosen earlier. Do remember that the writ system has now been abolished and the plaintiff does not have to choose one specific cause of action. But now it's not there. That used to be the case. We are talking about history. Notwithstanding, modern torts still follow this historical distinction. Distinction is there, but writs are not there. This system is not there. Such that any wrongful act following the original trespass, example, battery, assault, trespass to chattels, still require direct consequences before the plaintiff would succeed. That means the earlier knowledge that what was that earlier requirement was that direct harm, direct consequences was required. So that is still there. On the other hand, modern torts following the trespass on the case cover indirect consequences, sometimes indirect consequences, negligence, accidents, those things. And they are wider in scope. Those things are wider in scope. Direct to pata chalta na ki, it's easier to prove also. So those are trespass coming under the different category. And the other thing is trespass on the case, which cover indirect consequences. Nonetheless, the distinction between direct and indirect consequences are not always easy to make, as the case below will demonstrate. There is a case of Scott versus Shepherd. Okay, we'll just finish with this case and then we'll continue on the next class. So Scott versus Shepherd case, 1558. The defendant, a child, threw a lit squib, that is a firework, into the crowded marketplace and landed on Wise stall. So he just threw, and it was a child, and that landed on Wise stall. To prevent damage to his stall, Y quickly threw the squib, which landed at W stall, who also threw it at R stall, basically passing the ball over, but of a firework. Obviously, there will be, but earlier who did it? It was a child who threw it, right? But they then passed it on because they wanted to prevent themselves. This is true. They didn't target anybody. And R then threw the squib to another part of the market where it landed and exploded in the plaintiff's face only, blinding an eye. The plaintiff then sued the child for trespass against the person. मतलब उनका body में injury हुआ, so they sued for trespass against person. The defendant argued that he could not be held liable since it was R, not him, that actually threw the skib at the and that struck the plaintiff. So harm, direct harm concept comes here, that says, R is the person who directly struck the plaintiff. The issue here was whether the action of third party R rendered the defendant non-liable. So whether defendant here, the child, is non-liable because R did it. Is it true? The two of the judges held that the plaintiff's injuries were sufficiently direct to fit within the category of trespass. Yes, directly it is there. Injuries are falling under the category of trespass because it was bodily injury or harm to the person. Trespass on person. While the third judge dissented, ruling that the injuries were direct injuries and that he had sued on the trespass on the case, he would have succeeded rather than trespass be at arms. So the third judge, of course, there will be a assenting judge and dissenting judge. उन्होंने बोला कि एक person ने बोला कि no, it is not so. As per Justice Nares, I am of the opinion that the trespass could well lie in the present case. That is, trespass here, what they mean, trespass of person, okay? The natural and probable consequence of that act done by the defendant was injury to somebody, and therefore the act was illegal at common law itself. The throwing of squib has, by the Fireworks Act, etc., been since made a nuisance. Being therefore unlawful, the defendant was liable to answer for the consequences, the injury mediate or immediate. So basically, what they're saying, one of the justices is saying, like this comes under the trespass of person because the act itself was a wrong, right? So throwing it anywhere, it's a wrong thing. And when immediate or mediate, whenever it is affecting somebody, then the defendant has to be liable. And it is expressed as malice animus, which is not necessary to constitute a trespass. The principle I go on is what is laid down in Reynolds versus Clark, that if the act of the first instance be unlawful, trespass will lie. So this also you can underline. Reynolds, this case say that the act of the first instance be unlawful. That means the act of throwing the firework itself was a wrongdoing or unlawful. It was against the law. Then trespass definitely will come. Wherever, therefore, an act is unlawful at first, trespass will lie for the consequences of it. So in this yearbook, okay, in this, trespass lay for stopping a sewer with earth so as to overflow the plaintiff's land. So I do not think it is necessary to maintain trespass that the defendant should personally touch the plaintiff if he does not by a mean, it is sufficient. If he does it by any means, it is sufficient. Like here, what happened? Child threw it, the defendant threw it, and then it went to Y and Y to R and whatever, R to this person, plaintiff, right? So if he does it by any means, he put the motion in place. So that is sufficient. That mischievous faculty remained in it until the explosion. So he did not stop it, like he threw and like he didn't, diffuse it or something. It still continued, and because of his act, like he basically fired it and then threw. So that is sufficient. The person who turns him loose is answerable in the trespass for whatever mischief he may do. The intermediate acts of W and R will not purge on the original tort in the defendant, but he who does the first wrong is answerable for all the consequential damages. So, आपका exam में you might get a similar case where one person does something and other person are intervening. So ultimately, you have to recognize what has happened here, and you can take the case. This case loss help, and you can write the answer. Justice Blackstone, in his dissenting opinion, so this one was dissenting judge Blackstone, he said that argued that the defendant's act were too indirect and non-immediate to constitute trespass against the claimant. He noted that the actions of the third parties were sufficiently voluntary to break the chain of causation. The causation concept we understand in criminal law as well, that how the, what are the interferences happening on the cause of the action. Cause of action means why it happened, how it happened, the reason behind it. He concluded that the solid distinction between the direct and immediate injuries on the one hand and immediate on the or the consequential on the other, and the trespass never lay on the latter. This case in itself shows that the judges even in those days never agreed on what constituted direct and indirect. So basically, क्या था वहां पे तभी भी long back also there was no consensus by the judge saying that this is direct and this is indirect. So even if you get confused by it, it's fine. Okay, because the judges in the olden days also, they were also not so clear. So we will stop here for today. Any doubts on what we have learned so far?
No doubts.
Okay, so we have one more case law for this, and then we will be starting with the second chapter. I mean, not the second chapter. In the first chapter itself, there is another portion. And yeah, let me know how is the speed, and like, do you want me to go a little bit faster or how?
I think this is fine. This was
Yeah,
normal.
You are able to understand, no?
yeah.
Yes.
Okay. Thank you, guys. Thank you for joining. I'll see you in the
Thank
next
you,
class
Vidya.
tomorrow, same time.
From tomorrow, it will be the case that I'll sit till 8:30, 8:45. So I'll be ready for my office already. I'll sit for the lectures according to that.
Okay. So that means same time, no? Till same time, you mean?
Yes. Same time. Yeah, I can sit till 8:30 from tomorrow, 6:30 to 8:30.
Okay. Yeah. 6:30 to 8:30. That means 2 hours, basically.
Yes.
Yeah. Okay. Okay then. Take care.
Take care. Bye.
Bye bye.